Hello, my name's Karen Sanders and I'm a senior lecturer at London South Bank University in England. What I'd like to talk to you today about is consent. I'm aware that you may well be accessing this website from anywhere in the world, so I'd invite you to apply your own laws and legislation to what I have to say. I will be using UK law, UK professional codes and international human rights legislation in what I have to say. I would like to discuss the process of obtaining consent in 4 stages. The first stage that I'd like to discuss with you is that of the competent, autonomous adult patient. One of the first things that I think we need to do is to remind ourselves of the fact that a competent adult patient has both the right to consent to the prescribed treatment, but equally to withhold or withdraw consent to prescribed treatment. Such a withholding or withdrawing of consent may lead to the patient suffering from a poorer quality of life from our or their perspective, or even their death, but they have a right to do so. So the question we have to ask ourselves is this patient in front of us competent? In England and Wales we have the Mental Capacity Act 2007 that provides us with a clear framework as to how to do this. The first phase of the framework is that of diagnosis. The Act asks us to consider whether the patient has a diagnosis that will affect the functioning of their mind and or their brain. If such a diagnosis exists, the Act asks us to carry on to the next phase, which is that of function. And it asks us to consider, first of all, can the patient understand information that is being given to them? Secondly, is the patient able to retain that information? Thirdly, is the patient able to see the relevance of that information to their own life? And finally, is the patient able to communicate with us? The Act asks us to make sure that everything is put into place to enable the patient to do all 4 of these functions. If the patient is unable to achieve any of these 4 functions, then they can be labelled as incompetence. However, what must be remembered is that at the beginning of the process, the patient must be assumed to be competent. Therefore, competency must be disproved. The age of the patient, their appearance, their condition or aspects of their behaviour must not be brought into account in this situation. The fact is, if the patient is able to understand, retain, see the relevance in the information and communicate, they are, under British law, competent. In the unlikely event that you find yourself managing someone who is judged to be incompetent, the following actions must be taken. Again, the Mental Capacity Act is clear on this fact, and it says that what must happen is that you must seek the advice of anyone previously named by the patient, anybody engaged in the care of the patient, or anybody interested in the welfare of the patient. And what we must seek from these people is information regarding what they believe is in the best interests of this patient. In other words, what this patient would choose to do in this situation. We must also seek any written statements made by the patient whilst he or she was competent, or any statements written by others whilst the patient was competent. In other words, does this patient have an advanced decision, previously known as a living will? Has this patient been involved in advanced care planning of any kind? And also, what is recorded in previous medical and nursing records? All of these issues are important because what we must do at this stage is not do what we believe is best for the patient or what relatives, friends or carers believe to be best, but what the patient would want. I'd now like to address the final 3 components of the process of obtaining consent. The first component that I'd like to discuss with you is that of the possibility of the patient being coerced. We as practitioners must ensure that the patient is making a voluntary decision and that any accidental or deliberate coercion by ourselves, by other healthcare professionals or by families, friends or carers is excluded. The decision made by the patient must be their own decision. This does not prevent them from discussing the decision with us or with others, but it must be their decision. The next component that I'd like to discuss with you is that of the information that you provided the patient with. Has the patient been provided with adequate information to enable them to make the decision? Has the information been provided to them in such a way that they can both understand it and apply it to their own lives? Have you ensured that there are no deficits of knowledge? If deficits of knowledge exist, they must be filled, because only then is the patient able to make an adequately informed decision. Finally, have you given the patient sufficient time for them to make a decision? Have they been given sufficient time to deliberate over the information that you provided them with? If they haven't, then more time must be allowed, because only with sufficient time to deliberate and discuss the information with the relevant others, their family, their friends, yourself and other healthcare professionals, are they able to make their own voluntary decision. I hope this information has been useful to you and will be useful to you in your practice. I would ask you now to consider what I've said alongside the legislation in your own country, and also it needs to be supported by further reading. Thank you.